Court of Appeals of Tennessee is now in session.
All right, good morning again.
Good morning.
Wanted to tell the attorneys and parties how much we appreciate you participating in this process. This is a work in progress, and we're trying to make sure that the wheels of justice continue to turn. So we appreciate you participating with us. Before we get started, I want to first of all introduce our panel. We have Judge Arnold Golden from Shelby County, Judge Kenny Armstrong from Shelby County. I'm Steve Stafford from Dyersburg, and we'll be your panel this morning. We appreciate Mr. Hibner, who has been the quarterback and the mastermind of all this, and who has made the wheels turn, and the AOC staff who is working behind the scenes to make this go as well. When we get started, if you are the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but you'll need to do that after you introduce yourself, and you'll need to request that from the court. In just a minute, we will get started. We'll let Mr. Hibner call the case, and then we'll proceed on. And Mr. Hibner, I understand this is live streaming at this point in time. Is that correct?
Yes, Your Honor.
Okay. All right. You may proceed.
In re Conservatorship of Betty A. Winston.
All right. We'll hear from the appellant then.
Good morning. May it please the court, my name is Heather Staggs with West Tennessee Legal Services, and I represent the appellant, Andrea Lewin. I respectfully request 3 minutes for rebuttal.
All right. You may proceed.
Appellant in this case respectfully asks this court to reverse the trial court's decision or alternatively remand it to the trial court for the following reason. The trial court failed to make a finding of fact and conclusion of law as required by Tennessee Rule of Civil Procedure 5201. In order to have sufficient findings of fact and conclusions of law, the trial court was required to determine what was in the best interest of Betty Winston, considering all the relevant facts. The trial court issued a letter ruling stating that Allison Winston be appointed conservator of Betty Winston, finding that if she were appointed to be conservator, then Betty Winston would be able to remain in her own home and have Allison there to care for her on a daily and nightly basis. Having Betty Winston remain in her own home was the sole basis for the trial court's decision. The trial court ordered on May 31st of 2019, incorporating that letter ruling with the addition that Allison could not relocate her mother outside of Tennessee without the court's approval. However, on April 13th of 2020, Allison filed a motion for extension to file a brief, claiming that she has been living in California for months. On April 21st, an official order was entered, officially changing Allison's address to California. In Allison's own testimony at the May 21st, 2019 hearing, she misrepresented to the court that if she were appointed conservator, she would be able to remain in Jackson, Tennessee, employed and tend to her mother. At the time of the hearing, all of Allison's belongings were in California. She had an apartment, a car, and her employment was there. She questioned the guardian ad litem at the time how difficult it would be to take her mom to California, and if she would be able to transfer that conservatorship to California during that investigation. Under 5201, looking at all the relevant facts in this case, the evidence preponderates against the decision of the trial court. Not only is Betty Winston not in her own home, which was the sole basis of the trial court's decision, but there are
Just a second, counsel. Let me ask you a question. You're talking about things that have happened since the hearing. Is this in the record?
The motion for the extension to file a brief and the order changing the address is in the record. That was filed with the appellate court after I filed my brief.
These other things that you've mentioned about the ward being moved, about the conservator living in California, obviously we've got whatever pleadings have been filed, but there are no post-judgment findings of fact or conclusions of law or anything like that, are there?
No, Your Honor. This is just based on Allison Winston's own motion to the appellate court to change her address.
Okay, well, we need to constrain that to the things that we know are in the record, okay?
Yes, Your Honor.
Thank you.
Looking at the relevant facts of this case, there are numerous accounts of abuse in the record that were not discussed in the trial court's ruling. The trial court letter ruling mentions but entirely neglects to discuss the testimony of the 9 witnesses, Dr. Hammond's deposition, the guardian ad litem report, and the extensive medical records. The trial court provided no findings to support its contrary ruling against Dr. Hammond's recommendation or the guardian ad litem, and didn't discuss why he chose to disregard those recommendations or any findings of fact to support that. Every healthcare and social services professional that the guardian ad litem interviewed stated that this was the worst case of family interference of medical care that they have ever witnessed. The interference was such that Northbrook, where she was staying, would refuse future acceptance of Betty Winston in its facility and its sister properties. In one instance, in January of 2019, Betty Winston broke her hip after falling in a parking lot alone on January 9th. She was taken to the hospital in Jackson, Madison County, and the doctor stressed the importance to Allison Winston, who was the power of attorney, the importance of having this surgery. As of January 11th of 2019, Allison refused to authorize that surgery, and the hospital felt so strongly that they bypassed Allison's power of attorney and requested authorization from one of Betty Winston's other children, Russell Winston, who gave the authorization for the surgery. Dr. Jerry Hammond was also deposed in this matter, and when asked if appointing Allison was conservator would be in Betty Winston's best interest, he quoted, "After what I saw, I don't know, but I'd be a little scared. Everybody needs to be on the same page, otherwise they're going to have to give it to somebody who's neutral, or else it's going to hurt Betty Winston. She needs to have a calm, stable family life." In addition to the medical interference, there's numerous accounts of elder abuse in this case. Respondents' healthcare providers noted several bruises on Betty Winston. And when speaking with the guardian ad litem, Allison Winston herself acknowledged them and said that her mother had put makeup on to pretend that she had been abused. Allison Winston also testified at the hearing, saying that on one occasion in Northbrook, a nurse thought respondent had bruises on her faces, but respondent was just wearing too much makeup. Dana Holmes, who is a social services worker at a program at the Area Agency on Aging and Disability, testified that on occasions she met with Betty Winston, she observed obvious bruising and that these would not be from natural causes based on her experience.
Did the trial court make any findings regarding the alleged elder abuse?
No, Your Honor, there was no indication in the letter ruling about the verbal abuse or any indications of any instances of the abuse that have been notated in the record and at the hearing. Did the trial court make any credibility findings? No, Your Honor, there was no credibility findings. The letter ruling did not have any findings of fact or conclusions of law to support his decision, other than saying that it would be best for Betty Winston to remain in her own home. That was the sole basis for the trial court's decision. Moving forward into verbal abuse, there was an instance that involved Allison Winston and Betty Winston at the hospital that was detailed in Dr. Hammond's deposition, where Allison Winston became so angry at Betty Winston for trying to understand the medical advice given about her husband, Robert Winston, that she yelled at Betty Winston and told her that she could find her own way home. She then proceeded to leave Betty Winston at the hospital for hours without transportation. And when Allison Winston did return, it was in such a manner that security had to be called at that time. Russell Winston, another one of Betty Winston's children, also testified about an instance in October of 2018 that he arrived to pick up Betty Winston to take her to the VA hospital. And when he arrived, he found Betty Winston sitting on her porch, visibly distressed. Betty Winston told Russell at that time that she and Allison Winston had had an argument and that Allison Winston had thrown some objects at her. Then Allison Winston sent Betty Winston to the porch and locked her out of her home. And that's detailed in the record as well. None of these findings were found in the letter ruling that was given by the trial court. It does not discuss any of the above information. It doesn't name any of the witnesses, speak to the substance of their testimony. It doesn't speak to Dr. Hammond's deposition. It doesn't talk about the guardian ad litem report, which was thorough. It doesn't talk about any of these issues at hand and made no findings on that testimony. It neglected to discuss the testimony of the witnesses, the deposition, the guardian ad litem report, the extensive medical records in this case, and made no findings to support its contrary ruling against the recommendations that were put in place by Dr. Hammond and by the guardian ad litem. This evidence taken as a whole in conjunction with everything else that is in the record preponderates against the trial court's conclusion. The evidentiary support of the allegations of verbal abuse, medical interference, and Allison's inquiry into returning to California supports the finding of fact with greater convincing effect that it is not in the best interest of the Betty Winston for Allison Winston to be her conservator. In addition, as stated in the motions that Allison Winston filed with the appellate court, Betty Winston is not in her own home. Therefore, this court should reverse the trial court's decision, or in the alternative, remand it to the trial court for findings of fact and conclusions of law to support its decision. Thank you.
All right, we'll hear from the appellee. Ma'am, I understand you're representing yourself. Is that correct?
Yes, sir.
Okay. You understand you have 15 minutes to make your argument. You could tell us whatever you'd like about anything that's in the record, and you can make your legal argument as well.
Okay. Thank you.
Do you have any questions about anything?
No, sir.
All right. You may proceed then.
Good morning. Thank you for this opportunity to just reiterate a few points that were in my brief and concerning the conservatorship of my mom, Betty Winston. The appellant, I feel, is trying to get this court to reweigh the same evidence that Judge Butler already heard, which he, after 3 hours, had said was pretty much hearsay about all the allegations concerning me. They're, of course, false, I believe, with the same result. The only role of this court is to decide whether Judge Butler abused his discretion in making me conservator. He was already aware of the dysfunction between my siblings and I. He heard all the evidence for his ruling, and he applied the law, in my opinion, correctly. Contrary to appellant's contention, there's no ambiguity in Judge Butler's findings of fact and conclusions of the law. His rulings, stated clearly what he meant and why. This fully satisfies the requirement of Tennessee Rule of Civil Procedure 5201. Judge Butler properly decided that it would be in my mother's best interest, yes, to stay in her home and to have me appointed conservator, instead of having her become ward of the state. Neither one of my siblings have helped in 2 years. They weren't interested in helping my mother. They weren't interested in becoming conservator. No one wanted the responsibility. And pretty much in the year that I had returned to Tennessee, only come to town to take me to court. This is my 3rd court hearing in 1 year. Appellant misleads the court by putting words in my mouth that I have never said, like taking care of my mother was too great a burden, or that I'm unable or I'm unwilling to serve as conservator. I am the only boots on the ground for almost 2 years. Indeed, I am the only family member, who has stated a willingness to serve rather than making my mother a ward of the state. As far as the allegations that Ms. Staggs has said, I would like to briefly comment on those. When my mother entered the hospital, she was still driving and had broken a hip. And I entered the hospital, and my mother has had triple bypass. I asked the doctors at Jackson Madison County to test her and make sure her heart was okay before we had surgery. This was pretty much a general thing. They do this every day. And the doctor abided because I wanted to make sure my mother was okay for surgery. I was not the POA, I found out. My brother had come to town and had taken the POA away from me, and I was unaware of this until it was time for surgery. And all of these months, I thought I was POA over healthcare, and my brother was POA over, at the time, over the financial for my parents. I did not deny her any kind of surgery. 24 hours later, she had the surgery. My mother never stayed at Northbrook except for 2 weeks in the same room as my father was, against her wishes. And that was for rehab. And then she went home. As far as the elder abuse, look, I am not a perfect person. This has been, I've become a lawyer. I am a 24-hour caregiver, and I have never abused my parents. The bruises on my mother were from a blood thinner, and everyone knows that happens. You barely touch them and they bruise. My mother fell in the tub last week. She has a bruise on her arm, I will admit, from the Eliquis that she is on. She had a stroke. She is got to be on this medicine for the rest of her life. And instead of hitting her head and having another brain bleed, I'd rather her have a bruise on her arm for catching her. Dr. Hammond and I had maybe 3 or 4 at the most meetings, and primarily it was on the phone regarding my father. I never had any kind of interaction with him concerning my mother. He was not the doctor on staff that supposedly I had a run-in with and I was asked to leave the hospital. This is all hearsay. He was not the doctor that was handling my father. And I had 2 parents that I was taking care of. As far as my mother being on a porch and being locked out, my mother was sitting quietly on the porch waiting for my brother to pick her up. This is not in the record, but I feel it needs to be stated. My doors were locked because my brother.
Ma'am, you don't need to go outside the record. You need
Okay.
to, whatever,
Well, there was
if
a
it's
reason
not in
why
the
the doors
record,
were
we
locked.
can't consider it.
Okay. But my mother was fine on the porch. She was sitting there on her porch and waiting for him to pick her up. In conclusion, I feel that I have enhanced my mother's life in many areas. I stated this on my brief. And, you know, I feel that Judge Butler's ruling was sound. And, you know, my sister legally had 30 days to do this appeal. For 3 weeks, she assured me she would work with me. And then 2 days before her timing was running out, she got angry and filed an appeal. I just don't feel that this is necessary. I don't know why we are here. And honestly, you know, I stand behind Judge Butler's ruling, and I feel that he is a sound judge and a sound lawyer. He considered all the evidence. And unless the court has further questions, I appreciate your consideration and I appreciate your time. Thank you.
I see no further questions. We'll hear from the appellant. I think you have 3 minutes of rebuttal time.
Yes, Your Honor. This case really boils down to one issue, and that's that there was a lack of sufficient findings of fact and conclusions of law. The record in this case is over 2,000 pages, and the lack of findings of fact and sufficient conclusions of law, it was insufficient in this case. The things that Allison spoke about in her argument were not supported by the record. You know, the incidences I gave you, you can find in the record, but there were no credibility determinations made by the trial court to determine what the trial court based its decision on and what the considerations that they placed in basing their decisions. The trial court had a wealth of information available to them from Dr. Hammond's deposition, the extensive medical records, which were about 1,500 pages, the guardian ad litem report, the 9 witnesses that testified at trial.
Ms. Staggs, there does happen to be a sentence in the chancellor's letter ruling where he says, the court has listened to all of the witnesses and has judged everyone's credibility and motives in this case, and has come to the conclusion that the best interest of the respondent would be for Allison Winston to be appointed as a conservator for respondent. That seems to be an implication as to where the chancellor made his credibility rulings. Do you want to respond to that?
Yes, Your Honor. Even with that statement, the weight and the credibility was not broken down in his letter ruling. He did not talk about the names of the witnesses or what weight he placed on each of the witnesses' testimony or the substance of that testimony. Each witness.
Do you think he's required to do that?
Is there a legal response? Is there some legal support for that?
In order to find a sufficient finding of fact or conclusion of law, there needs to be enough subsidiary facts in the letter ruling or the conclusions of fact or conclusions of law in order to make that. And that's in Lovelace v. Copley. There's no bright line test for it, but it does say that it must include as much of the subsidiary facts as is necessary to disclose to the reviewing court the steps by which the trial court reached its ultimate conclusion on each factual issue. And that's in Lovelace v. Copley.
And where do you say he's lacking?
He doesn't provide any of the subsidiary facts. Even if he says he judged the credibility, there's no facts in the letter ruling to support for you to judge how he made that decision or what basis he placed on his decision. There's nothing in the letter ruling that details the substance of the testimony and the credibility he placed on that and what the reasoning behind why he made his decision. So it's hard for the appellate court to make their decision on how he made his decision on each factual issue that is at stake in this case.
Are you saying that the majority of the facts are disputed or undisputed?
In the original hearing, most of the facts are disputed.
Okay. All right.
Thank you.
Thank you. We appreciate your arguments, and we appreciate you participating in the process. What we will do, we'll review the record, and we will attempt to get you an opinion in this matter as soon as possible. But we again thank you for your participation. Mr.
Thank
Hibbert?
you, Your Honor.
This court is now in recess until 1 p.m.
Thank you, Jim.
Thank you.
Thank you all for participating. You can leave the meeting now.
Thank you.
Very
And
good.
we can go